Okay, it's 2 o'clock, so we're going to go ahead and get started. Hello, and thank you for joining us. I'm Jody Litton. Today's sexual harassment training has been approved through DLG for 1 hour of House Bill 810 credit. That's for those who are eligible. Please remember to stay on camera. Also, we would like for you guys to be as interactive as you can, so please ask questions. If you guys don't know how to do that, you can raise your hand or you can type it in the chat box. Also, if you run into any problems, to contact, you can call KACo and we can help you guys try to get your service restored. Today's presenter is attorney Carol Pettit with Vaughn Pettit Legal Group. Carol, I'm going to go ahead and hand it over to you.
Hi, everyone. Thanks for joining me for this hour-long presentation on sexual harassment in the workplace. I prepared a PowerPoint for you today so you can have visual reference as well as listening to me talk. I'm going to tell you a little bit about myself. That is my name, Carol Pettit. That is my contact information. I am panel counsel for both Kentucky Association of Counties, Kentucky League of Cities, and I generally represent, oftentimes on a private basis, governments all across the Commonwealth. So this is my focus, and this is the only type of work that I do. Oftentimes, perhaps too often, I have issues that arise that pertain to sexual harassment. Sexual harassment is not always what we think it is, and that's part of the reason that we're going to go through all this today. So hopefully we can kind of hit some things off at the pass. If you have questions, please feel free to just shout them out, unmute yourself. We can do the chat box. I can tell you this, the way this is set up, if you're waving your hand or something like that, I'm not going to be able to see you because you're off to my side. But I'm sure that everybody that's helping with this today will kind of try to get my attention, and we'll address the questions as they come in. I have 3 children and about 25 employees. I prefer for you to just pepper me with questions, and while they're fresh on your mind, you cannot distract me or deter me from my presentation today. I have years and years of multitasking. So if I say something or if you think of something as we're going through today, please just unmute yourself and shout it out. We'll stop and address it as we're going through. I did have a chance to review the sign-up sheet for today. I know that we've got a lot of folks that are in supervisory positions, constitutionally elected officers in here. You all, in large part, are the bosses. So this presentation today is intended to answer questions for you, to give you a broad overview, perhaps bring to your attention some things that you might not have considered were sexual harassment. So with that, what is sexual harassment? Here are the basics. Sexual harassment is unwelcome. That's a key word, unwelcome. Verbal, visual, or physical conduct of a sexual nature that affects the working conditions. Now, just because something is sexual harassment doesn't mean it's unlawful. I'm not telling you this so you have a better framework on how to get around things. I'm telling you this because I think it's important that you know accurately what the law construes as sexual harassment. Harassment becomes unlawful when it becomes a condition of the employment. A lot of people will know this as quid pro quo. You will do this for me and I will do that for you. It's also unlawful when it is severe and pervasive enough to create an environment that a reasonable person would consider intimidating, hostile, or abusive. An isolated incident isn't going to be enough. You do not have to panic if something slips out from you or one of your employees, words that shouldn't have been said, words that you later question whether they have been said. A single isolated incident isn't going to be enough to impose liability upon you or your county. Sexual harassment can occur in a variety of circumstances, including but not limited to the following. I think that when most of us think about sexual harassment, and I don't know why this is typically a male or a female in a supervisory position with somebody of the opposite gender. Especially in today's times, you should think about this. The victim does not always have to be of the opposite gender. The victim or the harasser can be male or female. unlawful sexual harassment may occur without economic injury or discharge of the victim. So something can be actionable legally without it being a detriment to the victim. So a concrete example of this is if someone complains, an employee complains that there has been an unwelcome advance or comment to them, and they also lost money because they lost time away from work or they lost shifts. It's not necessarily that they have to have some sort of economic loss or detriment in their job. It can still be actionable sexual harassment without that happening. Harassment does not have to be intentional. And that's one of the reasons why we're here today. I want to bring you to your attention things that you may not think of as harassing or actionable sexual harassment. One thing that I thought might be helpful, I have been defending governments for almost my entire legal career. So I'm going on 30 years of this now. And I thought, you know, one thing that might be useful for you all to see are some actual lawsuits that have been filed that have to do with sexual harassment. So you can put in context based on your personal daily experiences, what these things might look like when they come across my desk after a lawsuit has been filed. The first thing that I think is important for you to know is that harassment can happen both on and off the job. I have put on this slide that is in front of you an actual paragraph from a lawsuit that has come across my desk. We have redacted, you'll see multiple ones of these examples today. We've redacted names and identifying information. I'm gonna ask that you just take a minute and kind of look at that, and then we'll talk about it a little bit. Oh, I clicked too quickly, people, I'm so sorry. Back to that paragraph. If all of you had a chance to review that, I think I can click backwards and we can go back to it, yeah. All you had a chance to review that, I want you to put it in this context. The social media posts that were being referred to in this lawsuit that was actually filed and that I defended did not have the coworker tagged in it, did not make any specific reference, and they weren't even made while either one of them were working. But there had been scenarios going on in the workplace that led the person that eventually ended up filing the lawsuit to say, these were definitely meant for me. And I know you're probably sitting there saying, how could he or she know that those were meant and we're referring to them? This is not all we do. When we're defending a lawsuit, we sit and we look at all the scenarios surrounding it. We talk to the coworkers, those folks are known as witnesses, and the totality of the circumstances can show, in this instance it didn't, but it can show that a reasonable inference that a jury could take and run with that those comments were meant toward that individual. The person making the comments was that person's supervisor on occasion. So that's why that was problematic. We're going to go through a couple of, there are a couple of scenarios on this slide that is in front of you. Gives you two scenarios, and then we'll decide which, if either of these are sexual harassment. Scenario one, Leslie and Ben share a computer at work. One day, Leslie was scrolling Facebook when she got called away from the computer. She unknowingly left her Facebook account logged in. When Ben arrived for his shift, he began scrolling through Leslie's Facebook page and found, this says a PG-13 photograph of Leslie, but I'll tell you, this comes from an actual lawsuit, and I'm going to call it X-rated photograph of Leslie. He left it up on the screen and told their other coworkers about it. You're thinking about that. Is that sexual harassment? What Ben did when he scrolled through his coworker's Facebook page, that had been up on a work computer. Scenario 2. Michael is Pam's boss. One day, he told her to go into an isolated storage area of their office. He followed her in and closed the door behind them. He told Pam that he had slept with other female employees in the office and bragged to Pam that he was so good at sex, one of the women didn't want to get out of his bed. He then asked Pam to bend over and pick up a box. She refused and she left. Both of these are sexual harassment. And both of them are from real life lawsuits that I have had to defend with regard to different governments. And underneath each of the respective columns on this page, you will see the real life allegations that were filed that led to these scenarios. Something else that can constitute sexual harassment. Sexual harassment can include offensive remarks about a person's sex or gender. Examples: making insulting comments about someone's gender identity or sexual orientation. This is a topic that I have never had to discuss until the last few years. But as everyone in this room is aware, attitudes toward this and the prevalence of gender identity and sexual orientation being public knowledge is increasingly common, and it's something that we need to be cognizant of. Listed under here is a scenario from a real lawsuit that came across my desk and I defended. Take a moment and read the allegations that are posted there. And we'll have a brief conversation after that about why that constitutes or could constitute sexual harassment. And I should clarify, paragraph 16 and paragraph 27 that are on that slide, those are from different scenarios. So, paragraph 16. This is something that folks in a supervisory context should pay attention to. You should pay attention to your own behaviors. It may be intentional, it may be unintentional. From the day that jailer blank took office as jailer of that county, it became obvious he had a problem with women that worked at the jail. He would constantly undermine their authority in front of subordinate employees and inmates alike, would yell, cuss, and berate them in a concerted effort to run them off. I'm not offering this example to you today to say that this particular individual acted correctly or incorrectly. I am telling you that as folks that are in charge of employees, that you should pay attention to your own actions and your own words. Understand that everybody that you are speaking to or interacting with has a subjective interpretation of what you're saying. So you should make sure that you are making a concerted effort to treat everyone equally, preferably with civility and common courtesy. But if we're going to be rude, let's at least do it to everybody. Probably shouldn't have said that one. Treat everyone equally. Paragraph 27. In other instances, this individual was asked by a male superior to leave roll call so that he could talk directly to the male officers about her, a female being on the shift. Now, I'm going to submit to you, in that particular instance, I personally do not believe that the male supervisor had any intention of being offensive or making the female in that scenario feel uncomfortable or discriminated against. I believe he had nothing but good intentions. From that female's perspective, she was an employee in an almost entirely male-dominated profession, and she was the one that was being asked to leave the room. Now, I will tell you this, that supervisor, when I asked him about this, said, I just wanted to make sure that all the guys understood they needed to treat her with respect and equally. That's not how it came across to the female, and that's one of the reasons why this lawsuit landed on my desk. So be sure and treat everyone equally. Try to put yourself in their shoes. How would you feel if those comments were directed toward you, no matter how good the intentions are behind them? There are 3 types of sexual harassment in the law. We have verbal or written. This includes comments about a person's clothing, their personal behavior, a person's body, sex-based jokes, obviously requesting sexual favors, repeatedly asking that person out on a date, sexual innuendos, rumors about a person's sex life, and sending emails and texts which are sexual in nature. And it doesn't matter, let's go back to the video clip that started this. It doesn't matter if you're just forwarding it or if you're just CCing it to somebody. Don't send it. Oftentimes, I find in my first responder environments, I know I've got some sheriffs on here, I know I've got some jailers on here. There are, I find that there's conversations that are pretty commonplace and that everyone seems to be engaging in and enjoying and laughing. And I don't know the percentages of how often that turns into a lawsuit. Just because everyone there seems to be engaged in the conversation or everyone is laughing at the email or the text that was forwarded onto them doesn't mean that you're not putting your organization in a position where they could have liability imposed against them. The second type is physical. There are some scenarios that all of us can look at and say, that is definitely sexual harassment. But it also includes brushing up against a person, touching of a person or their clothes, kissing, hugging, patting, and stroking. I had a lawsuit, or actually I don't think it led to a lawsuit, but I had a scenario in recent years where there was an elected official that was, and a lot of y'all, elected officials, I mean, you are people that interact with people, you are friendly, you are open, that's how you get elected. This particular individual was not unlike a lot, or even most of the elected officials that I represent. He was very gregarious, very friendly, very touchy-feely person, would come in and just pat somebody on the shoulder or pat them on the arm, and I do that. I am that kind of person. I'm a touchy person. One of the employees found that particularly bothersome, and that ultimately became the subject of a formal complaint that was lodged against that elected official. One thing that I tell folks and my elected officials that I have to counsel that are in that type of scenario, and I will only backtrack just a little bit. Every person that I talked to, including the person that was bothered by it, said, I don't think he means to be harassing. I don't think that he means for that to bother anyone, but it did. So when talking to folks that are having that kind of complaint lodged against them, or elected officials just in your role generally, or people that are in a supervisory capacity, you have to pay attention to your, not only your verbal, communications, but your nonverbal communications. You're touching, you're patting people on a shoulder, rubbing somebody on their arm. That can all be perceived as an unwanted touching. I'm not saying that you have to change your whole personality and how you deal with people. I'm just saying be cognizant of the fact that not everybody appreciates that. The next type of sexual harassment is one that I've already mentioned. It's the one that we typically all think of when we're thinking about sexual harassment. That is the quid pro quo. That literally means this for that in Latin. And that's what we talked about earlier. I will do this for you if you will do that for me. I think we all understand that that is a no-no in the workplace. So the advice that I will offer to you is to play it safe. Don't test the parameters of what is and what is not harassment. Even if a subordinate or a coworker says it's okay, even if you say something, and this is kind of where we get into this, it has to be severe and pervasive. So let's play a everyday scenario. So you're walking through the office or the jail or the county judge's office, and you say something, and then you realize immediately after you've said it or you've done something, you pat someone on the shoulder and you think, oh, that they may not have wanted that. That's okay. You have recognized it, and hopefully you can use that and in the future kind of stay away from that kind of conduct or speech pattern. But it's not okay even if that person says it's okay. The person may say it's okay because they feel uncomfortable, or they don't want to tell you, that it's not okay. That in and of itself might make them uncomfortable. I mean, I can play that forward. I'm a boss. My employees might not want to tell me, yeah, when you said that, that made me uncomfortable, because that would make them think, well, maybe she's not going to like me as much. Maybe she's not going to give me the raise next year, etc. So even because somebody says it's okay, don't assume that it is okay. Even if it seems appropriate for the moment or for that context, understand that in 3 years, when a jury is listening to the same story, they don't have that same context. They were not in that scenario. They were not standing around, and they will not appreciate what it felt like in that moment, and it felt okay to say or do that thing. What are the effects of sexual harassment? When I get a sexual harassment lawsuit in addition to the allegations, the examples of which that you have seen in the preceding pages, and I've talked a little bit about, what we will hear is, here is how these fact patterns, these incidents, these things that happened had an effect on me. That's where we get into what we call the damages portion of the lawsuit. So in a civil litigation, there are two parts of a lawsuit. One is liability. Did something actionable happen? Did sexual harassment in this context, did sexual harassment occur in a scenario that the courts of the United States of America will say, yes, that was sexual harassment. If we get through that part of it, and the court determines that it is at least arguable that sexual harassment occurred, then that case will proceed toward one of two scenarios, 99% of the time. It's going to settle because the court has now ruled, probably as a matter of law, that sexual harassment could have occurred. We're going to let the jury decide. Or two, it's going to go to jury trial. When it goes to jury trial, the person that is making the allegations of sexual harassment is going to get to talk to the jury about the physical and emotional effects that that workplace scenario and environment had on him or her. These are some of the things that you will see or hear if you find yourself in that situation. Feelings of guilt. In the video that we just saw, that young lady probably felt guilty. He's trying to be a nice guy. He just doesn't understand that I really felt like I couldn't say anything, and I really wished he wouldn't have done or said some of those things. It can lead to changes in appetite and sleep disturbances. an inability to focus both on and off the job, feelings of shame and doubt. It's been shown to increase the risk of cardiovascular disease, aches and pains, post-traumatic stress disorder. Can obviously lead to loss of employment. That can either be voluntary, involuntary, or some combination of the two, humiliation or defamation, and depression. We have different bodies of law that govern sexual harassment on an entity. It is illegal and is regulated by both state and federal law. In federal courts, I would say probably 60% of my lawsuits with regard to this particular scenario are going to be in federal court, at least 40% to be in state court. Federal law is governed by Title VII of the Civil Rights Act of 1964. It prohibits employment discrimination based on race, sex, color, national origin, or religion. Discrimination based on sex includes sexual harassment. Kentucky has in large part mirrored that with the Kentucky Civil Rights Act that is codified in KRS 344.010. It prohibits discrimination of employees on the basis of sex, which includes sexual harassment. Sexual harassment can also have non-legal impacts on an entity, such as decreased productivity, increased turnover, and damage to the reputation. It is of note, generally speaking, and this has kind of been a trend or a shift over the course of my practice. It used to be that these types of claims were primarily brought in federal court. That had a 1-year statute of limitations. I will tell you this, the plaintiff's bar, which is the folks that are going to be doing the suing, the ones on the other side of the V is what I call them. So my opposing counsel when I'm defending your county, have figured out that the Kentucky statute gives them 5 years to sue under 344.010 that I just referred to and that is referenced up here on this slide. So it used to be that we could pretty much count on the 1-year statute of limitations being applicable. My opposing counsel that's doing the suing in these scenarios has finally caught on to the fact that Kentucky gives them 5 years. So we have longer and for folks to be aggrieved and to bring the lawsuits. Defending sexual harassment claims is expensive, and it can lead to huge verdicts. Since 1998, litigation surrounding sexual harassment has steadily increased following a Supreme Court, and that's the United States Supreme Court decision, that held that an employee is able to recover against an employer without showing that an employer was directly at fault. Sexual harassment claims have led to some major verdicts. Down there at the bottom are examples of some of them. $168 million in federal court, $95 million, which later was reduced to a paltry $40 million, and $20 million in New Jersey. Let's talk about the rights and duties of both the employees and the employers. If you're not in a supervisory role, or if you are supervising employees and one of the employees comes to you, it's helpful for you to know this information. Witnesses, coworkers don't have a duty to report the harassment on the job, but it doesn't mean that they shouldn't and that they won't. An employee's duty to report harassment that they're aware of arises when there's a potential hazard that may lead to workplace violence. And as a coworker, it's oftentimes perceived that they should be responsible for the actions of their coworkers. I have also had claims that were not a direct result of sexual harassment, bet that a person felt there was a hostile work environment because they were in the same area or were subjected to harassing communications to a coworker. So also please be cognizant of that. Duties as a supervisor, which, as I understand, the vast majority of the folks in this Zoom room are, supervisors are directly legally responsible for the safety, security, and well-being of their employees. Cited here on this slide for you is the federal regulation that gives us some guidance on that. An employer is responsible for acts of sexual harassment in the workplace where the employer or its agents or supervisory employees. So if you're the jailer or you're the sheriff, if your chief deputy knows about something, that's what we're talking about here. If they know or if they should have known. Unless it can be shown that there was immediate and appropriate corrective action taken. So there's going to be liability if something is going on and you are going to be legally responsible for that if it could be shown that you or your supervisory staff did know or should have known. That's why when some of these things come to your attention, it is so important that you take immediate action. Something I didn't say, and I usually do say when I'm talking about my contact information that was on one of those first few slides, I'm sure that Rich Ornstein here at KACo, and he will just love me for just dropping him in there, but Rich is really brilliant and a really great source of information. He is always available to field questions. If you have had a complaint, you become aware of a situation, you can call Rich. I'm also going to tell you that you can call me, and I am glad to either talk to you about it, or if I feel like it's something that needs to be dealt with by Rich or somebody here at KACo, I'm just going to refer you on to that person. I don't have my cell phone on that first slide, but I will give it to you. I will tell you that I do not answer phone calls 98% of the time if I don't know where it's coming from, so you might have to leave a message or shoot me a text, but it is 502. If you didn't write that down or you missed it and you need it later, just give a call to anybody here at KACo and they'll be able to put you in touch with me. An employer may also be responsible for the acts of non-employees. This is something that a lot of folks probably don't think about on a regular basis. When you're the supervisor, you're the boss, you're the constitutionally elected official. Everybody that works in that office is your responsibility while they're at work. It is your responsibility to protect them from a hostile workplace, and that includes sexual harassment. It is your responsibility to protect your employees if you knew or should know of something. I will give an example. This happened years ago at a previous law firm where I worked and I was a partner. If you all have heard me give these talks before, you may recognize this scenario, but I think it's a good example, and I think it's important for people to hear this, especially when you're the boss. I got into the elevator one day with one of the female staff members. She was a legal assistant, so she was not in a supervisory role. And the UPS man had just left, who I thought was just a very pleasant and funny person. I enjoyed talking to him. And she said to me, "Can you believe some of the things that he says and does?" And I had no idea what she was talking about. So up until that point, there really wasn't any duty on me, legally or as a human being. And I indicated to her, I have absolutely no idea what you're talking about. So she proceeded to tell me that the UPS man, every time he came in and spoke to or saw a female in that law firm that was not in a position of power, so the receptionist, the legal assistants, our runners, that he would make, I'm not even going to give you the exact examples because everybody in this room will agree that he shouldn't have been saying those things to anyone. I'm sure his wife would have agreed with that also. It says some downright nasty things and some things that really could have been perceived as almost violent. graphic and of a sexual nature. At that point, it was my duty to protect the employees in that workplace from the sexually harassing comments and arguably behavior of a non-employee. It was my duty to take steps to address that with that person's employer as someone that regularly had access to and came into my workplace. It's better to investigate complaints before they become complaints. A little play on words there. So the capital C in that title is a complaint, which means it's a legal pleading that is filed in court that initiates a lawsuit. The complaint above that is just somebody's coming to you complaining. So it's best to investigate complaints before they turn into the capital C complaints. You've got some paragraphs here. And these again are from actual lawsuits. Paragraph 26, on more than one occasion, the female employee had walked into roll call to find male officers watching pornography on their mobile phones. And let me extrapolate on that a little bit. And they didn't stop when she walked into the room, because that was just something I guess they were used to doing. When she reported the incidents, her complaints were ignored. In another instance, paragraph 28, the officers passed around a random picture on their mobile phone of an unknown female with her legs spread and joked that it was this female employee at the gym. She reported the incident and there was no action taken. Paragraph 29, female employee complained of being discriminated against on a call with other officers, which she reported to her superiors. Her supervisor later rather scolded her about that, and then nothing else was done. Now, I will tell you this. Those were disputed allegations. There was never any evidence that that actually did or didn't happen, but I will tell you this also. It has been my experience in the decades that I have been defending these types of lawsuits that the vast majority of the time, where there's smoke, there's fire. So be particularly cognizant of your own language, your own nonverbal communications. Be in tune to those of your employees, especially your supervisory staff. If someone comes to you and says that there has been some sort of complaint or something that just doesn't sound particularly right, it's best to get in there and talk about it instead of turning a blind eye and hoping that it'll go away and won't happen again. Prevention is the key. Employees need to know what is required to be reported. You, as supervisors, need to make sure your employees know what needs to be reported. If someone comes to you with a complaint, that employee needs to know that you need to know the facts of that complaint with as much specificity as possible, dates that things occurred, hopefully time. Some of you work in environments where there are video cameras. If you don't work in an environment where you know there are video cameras recording, as folks in elected office and in supervisory roles in a government, you should assume that you are being recorded at all times. So if an individual comes to you with a complaint and says this occurred, it's important that you get the date and time with as much specificity as possible, because if and when that comes to a lawsuit, and we're still talking about pre-lawsuit here, but if and when that comes to a lawsuit and it comes across my desk or one of my colleagues' desks, It is oftentimes very valuable because if we have specific date and time, we can go back and rewind that video. We can preserve that video, hopefully. Somebody may have a cell phone video. There may be some evidence that we can actually use to, well, you, in investigating it before the lawsuit happens, determine if that's actually happening. However, after a lawsuit has occurred, it is very useful to us to go back and look at the date and time in that scenario and say, look, here's the video, nothing like that occurred. Or in an unfortunate event that it did occur, we can evaluate how we want to deal with it. In addition to the dates and times, we need to know the name of the person. So many times people want to come to us and they don't want to name names. They come to you as supervisors. I don't want to get so-and-so in trouble. You need a name. You need a name in order to know what action you're going to take next. You need to know folks that were in the area or could have seen or overheard something inadvertently, because those people are going to be fact witnesses. They are going to be perceived, if we get to it, by a jury as probably a more objective witness, unbiased. Employees need to know who to report to. Probably you have some policy in place for the county and or for your particular area or department that says if there is a complaint, these are the steps that need to be taken. Talk to your immediate supervisor. If you do not feel comfortable talking to your immediate supervisor, please talk to their supervisor and keep going up the chain. One thing that has come up in recent years that is particularly challenging is when the complaint is actually against a constitutionally elected official. That's something that I encourage all of my governments to address head on. Look at your policies and see if it addresses what to do if the individual that the complaint is being lodged against is actually an elected official, because it can be somewhat different in the reporting route. And what we are seeing in lawsuits against the actual constitutionally elected official, and I think some of these lawsuits could have been headed off if there had been a provision in the policy, is my complaint was against the jailer. I don't mean to be picking on jailers today, but I had a lawsuit recently and that was the situation. Did you look at the policy to see what to do? Yes, I did. And the policy said, report it to my direct supervisor. And if I didn't feel comfortable reporting it to my direct supervisor, report it to the jailer. So I didn't know what to do. There needs to be something else in there. Report it to the county judge executive. It's true that the county judge executive and the jailer are both constitutionally elected officials, but at least that individual would feel like they had somewhere else to go that was provided in the policy and gave them guidance. If and when, I hope, you decide to look into a complaint, an employee that is alleging harassment needs to know how the investigation process will go. An employee that is making a complaint of sexual harassment needs to know we are going to look into that, and they need to know with as much specificity as possible how you're going to do that. I want you to write me in as much detail a complaint so I can base my investigation on that. Please have that to me within 24 to 48 hours. Then I'm going to discuss it with the county attorney. Then we're going to decide how to proceed, and we will keep you posted and let you know how the investigation is going and when you can expect to have some sort of conclusion to it. Here is a sample policy. If you would like me to provide that to you afterward, please just give me a call and I will be glad to do so. I'll try to wrap it up because it looks like we're getting toward the end. This slide details what I just mentioned briefly. What if the person being accused is a constitutionally elected official? I think we all know it's a little bit different if we've got a supervisory employee that is the one being accused and there is at least some substance to the complaint, an employee of the county can be fired or can be disciplined. When that individual is an elected official, we all know, or I think we all know, that an elected official cannot be removed from office without an act of the state legislature, and that's for good reason. And the reason that we suggest that there be some sort of procedure outlined in the actual policy, where to go in the alternative if the individual that is making someone feel uncomfortable is the elected official, is it makes that person feel like they have an outlet and should make the county feel a little bit more protected should a complaint arise. That's a complaint with a C. Jumping ahead a little bit, let's say you've done everything that you can do and you have investigated the complaint and you've taken appropriate action, you still end up getting sued. Here's the number one thing that I think it's important for people to be cognizant of as soon as a complaint of sexual harassment, lower C, or capital C, a lawsuit complaint has been filed. It is common for me to see sexual harassment lawsuits come across my desk that, quite frankly, after I've looked into the factual scenario, just either are totally groundless or aren't going to meet the definition of sexual harassment as required by the law. It's just not going to rise to that. It's an isolated incident, and the courts just aren't going to see that as sexual harassment. If that were it, my job would be a lot easier. But then we get into retaliation claims. As human beings, it is difficult to sometimes control our behavior and our reaction to complaints, either informal complaints or lawsuits, because they feel awful personal, especially when you're the supervisor and you're being named in the complaint as failing to act appropriately or failing to look into it as in depth as you should have, turning a blind eye and not seeing something. And a lot of times the things you're being accused of, they can feel really personal. Here's what the temptation is to treat that person differently. That can happen consciously or subconsciously, but we need to make sure that it doesn't happen. Because the biggest problem that I have, I can get a lot of these sexual harassment lawsuits dismissed for the reasons that we've already talked about. But what is harder for me to get dismissed is the retaliation claims. So once a complaint, whichever kind, has been lodged, make sure that we don't treat the person differently. Make sure that we do not consciously or subconsciously impose some sort of negative effect on that person. While you are investigating or looking into a complaint that has been lodged by an employee, it's crucial to attempt to separate the complainant and the person that is the harasser. I don't know what that looks like for you. It's difficult to counsel you all on that because all of you come from you're in different parts of your county government. Your counties are different sizes. They come from the very large to the very small. Sometimes it may not be practical to separate those two folks. But here's some things that no matter what the size or the structure of your government is, you need to pay attention to. That first little bullet point down there, you should get the folks away from each other while you're looking into it, but don't move the person that's lodging the complaint. That can constitute retaliation. Here's a concrete example. And I fully appreciate how difficult this may be for you all, given your individual organizations. Let's say that a night shift employee has made an allegation of sexual harassment against his or her supervisor. The easiest thing to do is to move the employee off a night shift or to a different night shift rotation for a while, because it's easier to move a regular employee than it is to move a supervisor. You need to move the supervisor. You shouldn't move the person that's making the complaint. That will be construed as something that's retaliatory. If you take them off night shift and they get a night shift differential, they're going to say, I lost money because they retaliated against me and took me off a night shift. If you just move them to a different night shift, they're on your A night shift, you move them to B night shift, they're going to say, I incurred inconvenience, emotional stress, and financial loss because I only had babysitters for my child on my A night shift and I didn't on my B night shift. Don't move the complaining person. Don't give time off to the person making the complaint, even if it's paid, because it will make them feel and it will look like we are punishing them. On the next page, we have concrete examples of actual lawsuits that have come to me of allegations of retaliation. Paragraph 29, in response to those reports, the plaintiff was retaliated against. She was forced to take a demotion from supervisor. She had her ambulance taken away, the one that she said was assigned to her. Her partner was taken away. She lost shifts. She was moved to night shift, isolated from others, and told that coworkers would not be promoted if they talked to her. Paragraph 34, on one occasion, she reported harassment in an email. Instead of investigating, her supervisor printed the email, approached her with it, asked if she had a problem with him, etc. You can read the rest. All of these actions should be avoided. I have some true-false questions, but it looks like we're just about out of time. So what I would like to do is ask if anyone has any questions. I don't hear anything, Jody.
There's nothing in the chat.
Okay.
Okay. Well,
Thank you all for your time today.
thanks, Carol.